Before we dive in, please remember that I am not a financial advisor, attorney, or real estate professional. This video is created for educational and informational purposes only. The scenarios and information discussed here should not be considered legal or financial advice. Every situation is unique, and it is absolutely critical that you consult with a qualified professional, like a real estate attorney or a certified financial planner, for guidance tailored to your specific circumstances. Imagine this for a second. It's a Tuesday morning. You're getting ready for work, sipping your coffee, scrolling through your phone. You walk to the mailbox, pull out the usual stack of junk mail and a few bills, and then you see it. A thick, official-looking envelope from a company you've never heard of. You open it and your heart stops. It's a collection notice, but not for a credit card or a medical bill. It's a mortgage statement for a house you haven't lived in, haven't even thought about in over a decade. A house you walked away from during the 2008 financial crisis, assuming the bank had foreclosed on it and sold it years ago. But the letter in your hand says you still owe $150,000. And with 10 years of unpaid interest, property taxes, late fees, and penalties, the new total is a staggering $320,000. They're threatening to garnish your wages, put a lien on your current home, and destroy the credit score you've spent the last decade carefully rebuilding. This isn't a plot from a horror movie. This is a real-world financial nightmare, and it's called a zombie mortgage. It's a debt that was supposed to be dead and buried, but it has clawed its way out of the grave to haunt you. And right now, across the United States, hundreds of thousands of these zombie mortgages are lying dormant on the books of banks and debt collection agencies, just waiting for the right moment to reanimate and attack an unsuspecting family. The question is, could one of them have your name on it? In this presentation, we are going to drag this terrifying financial monster into the light. My goal is to arm you with the critical knowledge you need to protect yourself, your family, and your financial future from this threat. We will break down exactly what a zombie mortgage is and the legal loopholes that allow them to even exist. I will reveal the crucial warning signs that you might have one of these lurking in your past, even if you think you're completely in the clear. We'll expose the single biggest mistake homeowners make that can accidentally bring these debts back from the dead. And most importantly, by the end of this, you will have a clear, actionable plan to discover if you're at risk and exactly what to do if you ever receive that dreaded letter. Staying with me could be the difference between financial security and a decade-long battle with a debt you thought was long gone. So, how is this even possible? How can a bank come after you for a house you abandoned years ago? The answer lies in a fundamental misunderstanding most of us have about the foreclosure process. We think it's a single event. You stop paying, the bank takes the house, done deal. But that's not how it works. When you get a home loan, you sign two primary documents. The first is the promissory note. This is your personal promise to repay the loan. It's an IOU to the bank. The second is the mortgage, or in some states, a deed of trust. This document doesn't represent the debt itself. It represents the lien. It's the legal instrument that gives the bank the right to seize your specific property as collateral if you fail to pay back the IOU from the promissory note. Think of it like this: the note is the debt. The mortgage is the chain connecting that debt to your house. Foreclosure is the legal process of the bank using that chain to take the house. Here is the critical million-dollar piece of information that most people miss. The bank can choose to sever the chain, but that doesn't automatically destroy the debt. During the Great Recession, millions of properties went into default. Banks were overwhelmed. They initiated foreclosure proceedings on countless homes. But in many cases, especially in areas where property values had absolutely cratered, the cost of completing the foreclosure, the legal fees, the property taxes, the maintenance, the insurance on a vacant property, was more than the house was even worth. So, the banks did something that seems unthinkable: they just stopped. They walked away mid-foreclosure. They never completed the process. They never took legal title to the property. From the homeowner's perspective, they got the notices, they packed their bags, they moved out, and they assumed the bank took over. They saw their credit get hit and spent years rebuilding. But from the bank's legal perspective, they simply wrote the loan off their active books as a loss for accounting purposes and left everything in a state of legal limbo. And here's the terrifying result. If the foreclosure was never legally completed, the title to that property never left your name. You are still the legal owner of that abandoned, dilapidated house you fled from 10 years ago. And because you're the owner, you're also responsible for a decade of accumulating property taxes, code violations from the city for overgrown yards or broken windows, and HOA fees. And because the promissory note, your personal IOU, was never satisfied through a completed foreclosure sale, the underlying mortgage debt is still technically alive. It's just been sleeping, waiting. That's the classic zombie mortgage scenario. The bank, or more likely, a hyper-aggressive debt buyer who bought your old loan for pennies on the dollar, realizes that the property that was worth $50,000 in 2011 is now worth $250,000 in today's market. Suddenly, that old forgotten debt is a gold mine. They resurrect the file, tack on a decade of fees and interest that have been compounding in the dark, and they come after you with the full force of the law. They can either restart the foreclosure on the now valuable property you didn't even know you still owned, or they can ignore the house completely and just sue you personally for the massive balance on that original promissory note. But that's only one type of zombie. There's another, more common variant that can affect you even if the bank did complete the foreclosure. This is what's known as a deficiency judgment. Let's say back in 2010, you owed $300,000 on your home. The bank foreclosed and sold it at auction, but because the market was so bad, it only sold for $200,000. That leaves a $100,000 shortfall, or a deficiency. Now, in some states called non-recourse states, the bank has to eat that loss. The house is the only thing they can take. But in the majority of U.S. states, which are recourse states, the lender has the legal right to sue you personally for that $100,000 difference. For years after the crash, most banks didn't bother. It was too expensive to chase down former homeowners who were already financially devastated. But just like with the other zombie mortgages, time has passed. People have gotten back on their feet. They have jobs, savings, and new assets. And these old deficiency rights are often sold to debt collectors who specialize in hunting down old judgments. They might wait 9 years and 11 months, right before the statute of limitations is about to expire, and then file a lawsuit against you for that old shortfall, plus a decade of accrued interest. You thought it was over when you lost the house, but the debt itself survived the foreclosure. It became a zombie, and now it's at your door. So why is this becoming such a massive issue right now? It's a perfect storm. First, as we mentioned, soaring property values have turned previously worthless properties back into valuable assets, incentivizing banks to resurrect old files. Second, technology has made it incredibly easy for debt buyers to track people down. They use sophisticated data mining and skip tracing software to find former homeowners who have recovered financially. And third, the sheer volume of distressed loans from the 2008 crisis means there is a massive inventory of these potential zombie debts still sitting in digital filing cabinets. As statutes of limitations in various states begin to approach their final deadlines, we are seeing a frantic last-minute rush by collectors to cash in before these debts expire forever. The clock is ticking, and for hundreds of thousands of Americans, it's about to strike midnight. And at the heart of this ticking clock is a phenomenon that sounds like something straight out of a horror movie: the zombie mortgage. It's a term that perfectly captures the terrifying experience of a debt you thought was long dead and buried, suddenly clawing its way back to life to haunt you. To truly understand the sheer panic this can cause, let's go back in time. Let's talk about someone we'll call David. David's story is like that of millions of Americans. Back in 2007, he was living the American dream. He had a good job in construction, a wife, 2 kids, and a modest 3-bedroom house in a quiet Florida suburb. He'd bought it a few years earlier, and like many, he had 2 mortgages. The first was his primary loan. The second was a smaller home equity line of credit, or HELOC, for about $50,000. He'd used it to put in a new kitchen and fix the roof. Life was good. Then 2008 hit. The Great Recession swept across the country like a tidal wave, and David's construction job was one of the first casualties. Suddenly, the dream became a nightmare. With no income, savings dwindling, he had to make impossible choices: feed his family or pay the bank. He did what any father would do. He focused on survival. He fell behind on his payments. First the second mortgage, then the first. The threatening letters started piling up, each one more severe than the last. Notice of default. Intent to accelerate. Foreclosure warning. His primary lender, the big national bank that held his main mortgage, eventually foreclosed. It was devastating. The family lost their home, the one they'd poured their lives into. They packed what they could, their lives stuffed into cardboard boxes, and moved into a small rental apartment across town. Their credit was destroyed. The shame and stress were immense. But in the chaos of losing his home, the second mortgage, that $50,000 HELOC, just faded away. The bank that held it sent a few letters, but then silence. David figured that since the primary bank had taken the house, The second loan was just wiped out in the process. A casualty of the bigger foreclosure. It made sense. How could they foreclose on a house that had already been foreclosed on and sold? For years he heard nothing. He slowly, painfully began to rebuild his life. He got a new job, his kids grew up, and the trauma of 2008 began to feel like a distant, painful memory. The second mortgage was a ghost, a forgotten chapter in a book he never wanted to read again. Fast forward over a decade. It's 2023. David gets a certified letter in the mail. He doesn't recognize the name of the company on the envelope, some LLC he's never heard of. He opens it and his blood runs cold. The letter claims he owes money on that old HELOC. But it's not $50,000 anymore. After more than 10 years of compounded interest, late fees, and penalties he never even knew were accumulating, the balance has ballooned to over $120,000. And the letter contains a terrifying threat. Pay up, or we will sue you. We will garnish your wages. We will seize your assets. David is stunned, confused. How is this possible? The house is gone. The original bank is gone. Where did this debt come from? This right here is the anatomy of a zombie mortgage. Here's what happened behind the scenes. In the cold, calculated world of high finance. Back when David defaulted, the original bank that held his second mortgage looked at the situation. The housing market had crashed. The value of David's house was now less than what he owed on his first mortgage. For the second mortgage holder, foreclosing would be pointless. They'd get nothing from the sale. So they did something called a charge-off. Now this is a critical point that trips up millions of people. A charge-off is an accounting term. It does not mean the debt is forgiven, canceled, or erased. It simply means the bank has decided it's a loss on their books for tax purposes. They've given up on collecting it themselves. But the debt itself is still legally valid. It's a sleeping monster. And what happens to these charged-off debts? They don't just disappear. The original banks bundle them up, thousands of them at a time, and sell them for pennies on the dollar to third-party debt-buying companies. These are specialized, often aggressive firms whose entire business model is to buy old, forgotten debt for cheap and then try to collect on it. A company might buy David's $50,000 debt for as little as $500. For them, even if they only collect a few thousand, it's a massive return on their investment. So this new company, this LLC David had never heard of, now legally owned his debt. They sat on it, sometimes for years, letting the interest and fees grow, waiting for the perfect moment to strike. They waited for David's financial situation to improve. They waited for him to get back on his feet. They might have even been watching his credit score, waiting for it to recover. And then, when he was finally stable again, they resurrected the debt from its grave. This is not a rare, isolated event. This happened with hundreds of thousands, if not millions, of second mortgages and HELOCs from the 2008 era. These were the loans most likely to be left behind in a foreclosure. The primary lender got the house, and the second lender was left with an unsecured, sold-out junior mortgage. They charged them off, sold them, and created an army of financial zombies, lying dormant on the hard drives of debt collectors across the country. For years, these zombies were quiet, but now they are waking up. Why now? Because of the very thing we talked about at the start, the statute of limitations. In many states, there's a deadline for a lender to sue to collect a debt or to foreclose on a property. For a long time, there was legal confusion about when that clock started ticking. But recent court rulings, particularly in key states like New York and Florida, have clarified the law, establishing firm deadlines. For debt collectors holding these decade-old mortgages, it's a do-or-die moment. They know that if they don't act now, their multi-million-dollar investment in old debt will turn to dust. That $50,000 loan they bought for $500 will become legally uncollectible, worth zero. This is why we are seeing this sudden, frantic explosion of collection activities and foreclosure threats on debts that homeowners thought were ancient history. The collectors are in a race against time, and they are using every tactic at their disposal. They send intimidating letters filled with legal jargon. They make relentless phone calls. They threaten lawsuits and foreclosure, even if the legal standing for that foreclosure is shaky. Their goal is to scare people like David into paying something, anything, before the clock runs out. They're counting on the fact that most people don't know their rights. They're betting on the fear and confusion that a letter like that creates. They know that the memory of the 2008 crisis is a deep wound for many, and they are pressing on that exact spot, hoping to draw blood. The psychological toll is immense. It's a feeling of utter helplessness. You survived the worst economic disaster of a generation. You clawed your way back inch by inch to rebuild a life. And then more than a decade later, the ghost of that failure reappears, bigger and uglier than before, threatening to pull you right back down into the abyss. Feels profoundly unfair. Feels like a trap. And the most frightening part is that many people who are at risk have no idea. The original loan might not even be on their credit report anymore. They've heard nothing for 10, 12, even 15 years. They assume quite reasonably that it's over. They may have even bought a new home since then, believing their name was clear. But this zombie debt can lie hidden. A silent lien attached to their name, just waiting for a collector to reanimate it. The question is, how do you know if one of these financial zombies is shuffling silently towards your front door? How can you find out if a forgotten debt from your past is about to come back to life? Well, the first sign is almost always subtle. It's not a knock at the door in the middle of the night. It's a piece of mail. An envelope you almost throw away, mistaking it for junk. It might be from a company you've never heard of, a law firm in another state, or a debt collection agency with a generic, forgettable name like Portfolio Recovery Associates or Midland Credit Management. The letter itself is often intentionally confusing. It won't say, "You owe us $100,000 for that house you lost in 2011. It's more sophisticated than that. It might be phrased as an informational statement or a notice of servicing transfer. It might even say in small print somewhere, "This is an attempt to collect a debt." That's your first clue. That's the first twitch of the corpse. Let's imagine a homeowner, we'll call him David. David lived in Florida, one of the epicenters of the 2008 housing crisis. He had a good job, a family, and a 3-bedroom house with a mortgage he could afford. Until he couldn't. His company downsized, his income was cut in half, and suddenly that mortgage payment was an impossible mountain to climb each month. He tried for a loan modification, but the bank buried him in paperwork. Finally, defeated, he received a notice of foreclosure. He saw the writing on the wall. He packed up his family, gave the keys to the bank in a cash-for-keys deal, and moved across the country to start over. He thought that was the end of it. He saw the foreclosure filed in the public record. He assumed the bank took the house, sold it, and his nightmare was over. For 12 years it was. He rebuilt his life. He got a new job, improved his credit, and even managed to buy a small condo. The Florida house was a painful memory, a ghost from a past life. Then one Tuesday he gets an envelope. It's from something called Wilmington Trust, N.A. As trustee for the benefit of the holders of a mortgage-backed securities trust, Series 2007 AR1. It's a word salad of legal and financial jargon. Inside is a statement about a loan. His old loan. It lists a principal balance of $172,000. David laughs. It has to be a mistake. Scam. He hasn't thought about that house, that loan, in over a decade. He almost throws it in the shredder. But something stops him. A tiny, cold knot of dread in his stomach. This is the moment of truth. This is where you, if you're in David's shoes, have to become a detective. Your first and most important step is to not panic, and absolutely do not call the number on that letter. We'll get into why later, but for now just know that engaging with them before you have all the facts is like walking into an ambush unarmed. Instead, David does the first smart thing. He goes online and pulls his credit reports from all 3 major bureaus: Equifax, TransUnion, and Experian. You can do this for free once a year at annualcreditreport.com. He's looking for any mention of his old mortgage. And there it is. On his TransUnion report, buried in the closed account section, is the original mortgage from his old bank. It's marked as charged off, an account transferred or sold. Bingo! Let's break that down. Charged off is an accounting term. It doesn't mean the debt is gone. It just means the original lender has written it off their books as a loss for tax purposes. They've given up on collecting it themselves. But the key phrase here is account transferred or sold. This means they didn't just write it off. They bundled it up with thousands of other bad loans and sold it for pennies on the dollar to another company. That company is likely the entity that sent David the letter. The debt isn't dead. It just has a new, more aggressive owner. So step 1 for you. Pull your credit reports. Look for old mortgages. See how they are listed. Is it paid in full? Foreclosure completed? Or is it charged off? Is there a note about it being sold? This is your first piece of evidence. But David's a little savvier than that. He knows a credit report is just one part of the story. The real story of a property is written in the public record. So his second step is to go to the website for the county recorder or clerk of court for the county where his old Florida house was located. Every county in the United States maintains public property records. You can usually search them online for free. He searches by his name and the property address. He finds the original mortgage document from when he bought the house. He finds the lease pendants, which is the legal document that officially started the foreclosure process. He scrolls through the records year by year, and then he sees what isn't there. There is no final judgment of foreclosure. There is no certificate of title transferring ownership to the bank. And most importantly, there is no satisfaction of mortgage or deed of reconveyance. This document is the golden ticket. It's the official legally recorded paper that says a mortgage has been paid off and the lien on the property is released. Without it, from the county's perspective, the loan is still technically active. The bank started the foreclosure, but for some reason they never finished it. Maybe the paperwork was lost in the chaos of 2008. Maybe the bank itself went under and was acquired by another bank that dropped the ball. Maybe the cost of completing the foreclosure was more than the house was worth at the time, since property values had plummeted. Whatever the reason, they walked away, leaving the legal title to the house technically, bizarrely, still in David's name. They abandoned the process, but they never extinguished the debt. This is your second and perhaps most critical step. Search your county's public records. Look for the property you thought you lost. Can you find a final foreclosure judgment? Can you find a document that officially releases the mortgage lien? If you can't, you have a major red flag. The zombie is not only real, it's been sleeping in a legal limbo, and it's starting to wake up. David now has two powerful pieces of evidence: his credit report showing the debt was sold, and the county record showing the foreclosure was never completed and the lien was never released. He's starting to understand the gravity of the situation. The letter wasn't a scam. It was a summons. There's one more place David could look: a slightly more obscure but powerful tool called the MERS system. MERS stands for Mortgage Electronic Registration Systems. It's a private database created by the big banks to track servicing rights and ownership of mortgages as they are bought and sold. You can go to their website, MERS Servicer ID, and search by your property information. It can sometimes tell you who the current owner or servicer of your loan is supposed to be. In David's case, a search might reveal that his original loan was sold from his bank to Bank of America, then to a trust administered by Deutsche Bank, and finally to the entity that sent him the letter, Wilmington Trust. He can see the chain of custody. He can see the path the zombie took from the original bank's graveyard to his new mailbox. So let's recap the playbook. First, a strange letter arrives. Don't call them. Second, pull all three of your credit reports. Look for the status of the old mortgage. Third, and most importantly, search the public records of the county where the property is located. Look for proof that the foreclosure was finalized and the mortgage lien was released. If that proof is missing, you have a problem. David has done all this. The cold knot of dread in his stomach has now turned into a block of ice. He is the legal owner of a house he hasn't set foot in for 12 years. A house that has been sitting vacant, accumulating property taxes, code violations, and HOA fees. And worse, he's just been notified that a new company believes he owes them hundreds of thousands of dollars on the original mortgage, a debt that has been quietly accruing interest for over a decade. He is trapped. The ghost from his past isn't just a memory. It's a legally recognized monster, and it's now standing on his new doorstep, holding a bill. His situation feels hopeless. He's facing a massive, faceless financial institution that has just declared its intention to collect. What can one person possibly do against that? What are his rights? Does the statute of limitations protect him? Can they really come after him for this after all this time? The answer is complicated, and it depends on what he does next. Because the very first move he makes, the first phone call, the first letter he sends, could either be the first step toward freedom, or it could be the mistake that resets the clock on his debt and seals his fate for good. So what is that first move? What's the cardinal rule when a ghost from your financial past materializes in your mailbox? The most common, most human, and most disastrous response is to pick up the phone. Imagine David, his heart pounding, a cold sweat on his brow. The letter is filled with intimidating legal language, threatening foreclosure, credit destruction, and lawsuits. It lists an 800 number. His instinct, like yours or mine would be, is to call that number and try to reason with them, to explain his situation. Let's play that out for a second. He dials. A surprisingly friendly voice answers. Sterling Asset Recovery, this is Jessica. How can I help you? David, flustered, starts explaining. Hi, I got this letter about an old mortgage on my property at 123 Elm Street. I thought this was all settled years ago after the foreclosure. Jessica's voice is calm, reassuring. I understand this can be confusing, Mr. Henderson. Let me pull up your file. Yes, I see it here. It looks like there was a remaining balance on that second mortgage from 2 Riverbank. We've recently acquired the account, and we're just trying to get it resolved. David feels a slight sense of relief. Maybe this is just a misunderstanding. He says, but that was over a decade ago. I haven't heard a thing about this since then. And then Jessica lays the trap. It's a subtle, masterfully crafted trap. I see that, sir. And we're not unreasonable. We understand you weren't aware of this. Look, the records show the outstanding balance is $34,722. But to show good faith, we just want to get you on a path to resolution. Can you make a small payment today? Even just $50. It won't solve everything, but it will stop the more aggressive collection actions and show that you're cooperating. Right there. That's the moment. In this hypothetical scenario, David, wanting to make the problem go away, desperate to stop the threatening letter, says, okay, yes, I can do $50. He gives her his debit card number. The $50 is processed. Jessica thanks him, tells him they'll be in touch to set up a formal payment plan, and they hang up. David breathes a sigh of relief. He thinks he just bought himself some time. He thinks he just did the responsible thing. But what he actually just did was pull the pin on a financial grenade and toss it into the middle of his own life. Because in the eyes of the law, in most states, that $50 payment, or even just verbally acknowledging the debt on that phone call, saying something as simple as, I know I owe the money, I just can't pay it all right now, is a fresh admission of liability. He has just single-handedly resurrected a debt that was legally dead and unenforceable. He has reset the clock. This brings us to the single most important concept you need to understand when dealing with old debt: the statute of limitations. This isn't some obscure legal theory. It's your most powerful shield. A statute of limitations is a law that sets the maximum amount of time that legal proceedings can be initiated after an event. For debt, it means there's a limited window in which a creditor or debt collector can sue you to collect. Once that window closes, the debt isn't technically erased. It still exists, but your obligation to pay it becomes legally unenforceable. They can ask you for the money, but they can't use the courts to force you to pay. The debt is, for all intents and purposes, a ghost. But here's the critical part. The statute of limitations on debt varies wildly from state to state. In a state like Kentucky or Rhode Island, the limit for written contracts can be as long as 15 or 10 years. But in other states like North Carolina or California, it can be as short as 3 or 4 years. And what triggers the start of that clock can also vary. It's usually from the date of the last payment or the date the account first went into default. For over a decade, the clock on David's second mortgage had been ticking away, unheard, unseen. The statute of limitations had almost certainly expired years ago. That $34,000 debt was a fossil, legally uncollectible. But with that one phone call, that $150 payment, David would have reset the clock back to zero. The statute of limitations would start all over again from the date of that new payment. He would have given Sterling Asset Recovery the legal ammunition they needed to sue him, to get a judgment, and to foreclose on his home. A home he now owned free and clear. He would have turned a ghost into a monster with one panicked 5-minute phone call. But David Henderson didn't do that. He read the letter, felt the fear, felt the panic rising in his chest. He saw the 800 number, and he put the letter down. He walked away from it. He took a breath. And he did the single most important thing anyone can do in this situation. Nothing. He did not call. He did not engage. He did not admit to anything. His first move was to arm himself with knowledge, not words. He went to his computer and started searching. He searched for the name Sterling Asset Recovery. He searched for zombie second mortgage. And he searched for debt collection rights. What he discovered was a federal law that would become his sword and his shield. The Fair Debt Collection Practices Act, or the FDCPA. The FDCPA is a consumer protection law that lays out the rules for debt collectors. It dictates what they can and cannot do. They can't harass you, they can't lie to you, and they can't use unfair practices. But most importantly, the FDCPA gives you, the consumer, a powerful right. The right to demand validation of the debt. A debt collector can't just claim you owe money. If you ask them to, they have to prove it. They have to provide documentation that shows you are the person who owes the debt, the amount is correct, And this is the crucial one for zombie mortgages, that they are the legal owners of the debt and have the right to collect it. So David's first real action wasn't a phone call. It was a letter. A very specific, very powerful letter. It's called a debt validation letter. He found templates online from consumer protection websites. He spent an entire evening crafting it, making sure every word was precise. His letter didn't explain his situation. It didn't argue. It didn't make excuses. It was cold, clinical, and professional. It stated clearly that he was disputing the validity of the alleged debt, and that he was exercising his rights under the FDCPA. He demanded that Sterling Asset Recovery provide him with specific pieces of information. He asked for the name and address of the original creditor, 2 River Bank. He demanded the original account number. He demanded a copy of the original signed loan agreement. He demanded a complete payment history, showing how they arrived at the $34,000 figure, with a full breakdown of principal, interest, and any added fees. And the kill shot, the request that often stops zombie debt collectors in their tracks. He demanded proof of their legal standing to collect the debt. He wanted to see the unbroken chain of assignment, the paper trail showing that 2 River Bank had legally sold the debt, and that it was eventually sold to Sterling Asset Recovery. He was asking them to prove they weren't just a random company that bought a list of old debts for pennies on the dollar. He was asking them to show their work. He ended the letter with a clear instruction. All future communication must be in writing and sent to his mailing address. He was cutting off the phone calls before they could even start. He printed the letter, signed it, but he didn't just drop it in a mailbox. He took it to the post office and sent it via certified mail with the return receipt requested. This is a non-negotiable step. It costs a few extra dollars, but it provides him with a green postcard, signed by the recipient, proving the date and time that Sterling Asset Recovery received his demand. It was his proof, his evidence. As David walked out of the post office, the fear hadn't vanished, but it was now mixed with something else. A sense of control. He hadn't solved the problem, not yet. But he had made the first move. He had refused to be a victim. He had put the burden of proof squarely back where it belonged, on them. The ball was now in their court. And now the game had truly begun. The debt collector's return volley didn't take long. A week later, another envelope arrived. Same logo, same intimidating letterhead. But this time the tone had shifted. It was less of a generic demand and more of a direct reply to James's certified letter. They included a few printouts, a computerized ledger showing a balance, a date, and a series of charges. They claimed this was the validation he had requested. They stated their client, a faceless entity called Lionheart Acquisitions LLC, was the current holder of the note and had every legal right to collect. The letter ended with a thinly veiled threat. Failure to arrange payment within 15 days will result in our firm recommending our client pursue all available legal remedies. To the average person, this would be terrifying. It looks official. It uses legal-sounding language. It provides what looks like proof. Most people would see that ledger, that new LLC name, and that threat, and their resolve would crumble. They'd pick up the phone and try to make a deal, any deal, just to make it all go away. But James wasn't the average person anymore. The past few weeks of sleepless nights had forged him into something else. A student of his own predicament. He had been living on legal forums, consumer protection websites, and devouring every article he could find on the Fair Debt Collection Practices Act, or the FDCPA. And as he looked at the letter, he saw it not for what it was trying to be, but for what it actually was: a bluff. A high-stakes poker player showing a pair of twos and hoping you'll fold your full house. That computerized ledger? It wasn't proof of anything. It was just a spreadsheet someone typed up. It wasn't the original signed promissory note. It wasn't the deed of trust. It didn't show how Lionheart Acquisitions LLC had legally acquired the debt from the original lender, who had gone bankrupt a decade ago. It showed no chain of title for the debt itself. Think of it like a car title. If you want to prove you own a car, you don't just show a spreadsheet of your car payments. You show the official title from the DMV with your name on it. If someone else sold you the car, you need to see the title signed over from them, and from the person before them all the way back to the manufacturer. Debt is no different. They had shown him a receipt, not the title. And that was their first big mistake. This realization led James down an even deeper rabbit hole, and he stumbled upon the single most powerful weapon a homeowner in his position has: the statute of limitations. Now, this is a legal concept that sounds complicated, but the idea is actually very simple. A statute of limitations is basically a legal expiration date. It's a law that sets a maximum amount of time that parties have to initiate legal proceedings from the date of an alleged offense. In the criminal world, it's why you can't be charged for petty theft that happened 40 years ago. And in the civil world, it applies to debts. A creditor can't just wait forever to sue you for an unpaid debt. Each state has its own laws, but generally for written contracts, this period is somewhere between 3 and 10 years. James's heart started pounding. The original foreclosure was filed back in 2008. The bank had accelerated the loan. Now acceleration is a key word here. When you miss a few mortgage payments, the bank can accelerate the loan, which means the entire balance becomes due immediately. Not just the missed payments, but everything. And that moment of acceleration is critical, because it's the gunshot that starts the stopwatch on the statute of limitations. The bank declared the entire debt due in 2008. They had a certain number of years from that date to finalize the foreclosure and collect what was owed. James lived in a state with a 6-year statute of limitations on mortgage debt. He did the math. 2008 plus 6 years is 2014. It was now well past that. The legal expiration date on his mortgage had, in all likelihood, passed years ago. The debt was legally unenforceable. It was a ghost, a phantom that could send scary letters, but had no actual power to haunt him in a court of law. This debt collector, Lionheart Acquisitions, had likely bought this expired debt, along with thousands of others for pennies, or even fractions of a penny, on the dollar. Their entire business model wasn't based on having a solid legal case. It was a numbers game. They send out 10,000 scary letters, and if just 1 or 2% of people get scared and pay anything, they make a massive profit. They weren't expecting a fight. They were expecting fear and ignorance. They had found neither in James. Armed with this new knowledge, James felt a surge of power he hadn't felt in over a decade. He wasn't just a homeowner anymore. He was a warrior defending his castle. He sat down to write his second letter. This one would be different. The first letter was a question. This one would be a statement. He started by addressing their proof. He stated clearly and calmly that the documents they sent did not constitute proper validation of the debt under the FDCPA. He demanded a full accounting, including a copy of the original signed promissory note, and a complete chain of assignment showing how the debt traveled from the original, now defunct bank, all the way to their client, Lionheart Acquisitions LLC. He was calling their bluff, demanding they show their hand. Then he delivered the killing blow. He brought up the statute of limitations. He cited the specific state statute by number. He detailed the timeline. The initial loan, the 2008 foreclosure filing and acceleration of the debt, and the 6-year period that had since expired. He wrote, "Any attempt to collect on this time-barred debt through litigation would be a frivolous lawsuit and a direct violation of the Fair Debt Collection Practices Act, for which I would be entitled to seek statutory damages." He wasn't just defending anymore. He was on the attack. He was informing them that not only did they have no case against him, but that he might very well have a case against them. He was turning the tables completely. He was using the very laws designed to protect consumers as a sword. He wasn't just saying, "Prove it." He was saying, "This debt is legally dead and you know it. And if you keep harassing me, I will be the one taking you to court." He made 2 copies, one for his records and one that he sent once again via certified mail with a return receipt requested. As he dropped the envelope into the mailbox, the feeling wasn't one of fear or anxiety. It was one of cold, hard certainty. He had laid a trap. He had quoted the law back to them. Now, he would wait and see if they were foolish enough to walk into it. The silence that followed was deafening. A week went by. Then 2. No letters. No phone calls. It seemed for a moment that the ghost had been vanquished, that the bluff had been called, and the bully had retreated. But James knew better. This wasn't over. This was just the quiet before the storm. The debt collector had 2 options: disappear forever, or escalate in a way James couldn't possibly predict. He had poked the bear, and now he had to wait to see if it would run away, or come charging out of the cave, ready for a fight to the death. For weeks, the silence was deafening. James checked the mail every day, half expecting another letter, another threat. But nothing came. The phone didn't ring. He started to believe it was over. He'd done it. He'd stood up to the bully, sent his certified letter citing the Fair Debt Collection Practices Act, and the bully had tucked its tail and run. He had poked the bear, and the bear, it seemed, had decided to go back into hibernation. He and his wife celebrated with a nice dinner out, A weight lifted from their shoulders. They had their home, they had their peace, and the ghost of that old debt was finally seemingly exorcised. It was a fatal miscalculation. He had mistaken silence for surrender. In reality, it was the quiet before the storm. The bear hadn't run away. It had gone back into the cave to sharpen its claws. It happened on a Tuesday morning. James was getting ready for work when the doorbell rang. He opened it to find a man in a nondescript polo shirt holding a clipboard and a thick manila envelope. The man asked, "Are you James Miller?" When James confirmed, the man handed him the envelope and said, "You've been served." Then he turned and walked away without another word. James stood in the doorway, the weight of the envelope feeling like a brick in his hand. His heart hammered against his ribs. He knew instinctively that this was it. This was the escalation. This was the bear charging. He closed the door, his hands trembling slightly as he tore open the envelope. Inside was a stack of papers, dense with legal text, stamped with the official seal of the county court. At the top of the first page in bold letters were the words, "Summons and complaint for judicial foreclosure." He scanned the pages, his eyes catching terrifying phrases: default on promissory note, acceleration of debt, foreclosure of mortgage, public sale of property. The plaintiff wasn't some fly-by-night collection agency. It was a trust, an entity with a long sterile name. Sequoia Mortgage Trust 2007. The debt collector he had been dealing with was listed as the servicer, acting on behalf of this trust. They weren't just asking for money anymore. They were suing him to take his house. This is the nuclear option for a zombie mortgage holder. When letters and phone calls fail, and especially when a homeowner fights back, they often move to the ultimate leverage, the foreclosure lawsuit. It's a brutal, terrifying, and incredibly effective tactic because it transforms a dusty old debt into an immediate, existential threat to your family's shelter. The documents James was holding were designed to do one thing: overwhelm and intimidate him into submission. Let's break down what he was looking at, because if you ever face this, you need to understand the weapons being used against you. The first document was the summons. Think of this as an official invitation to a fight you didn't ask for. It's a formal notice from the court that a lawsuit has been filed against you, and it tells you that you have a specific amount of time, usually 20 to 30 days, to file a formal response called an answer. If you ignore the summons, you lose by default. The court will assume you have no defense, and the plaintiff, the trust suing you, will get everything they asked for. They can get a default judgment, and the court will schedule your home to be sold at auction. Doing nothing is the single worst mistake you can make. The second, much thicker document was the complaint. This is the heart of the lawsuit. It's where the plaintiff lays out their story. It's their version of events, detailing why they believe they have the legal right to take your home. It alleges that a loan was made, a mortgage was signed, payments were missed, and that they are now the rightful owner of that debt and have the authority to foreclose. Attached to the complaint were copies of documents they claimed were proof: a copy of the original mortgage from 2006 and a copy of the promissory note. But as James looked closer, he saw that the note was endorsed in blank, like a signed check with no one's name on it, and the mortgage listed the original lender, a bank that had imploded more than a decade ago. How did this Sequoia Mortgage Trust get involved? The complaint was vague on that critical detail. Buried in the legal paperwork, James's wife noticed something else had been filed with the county recorder's office: a document called a lease pendens. It's Latin for suit pending. This is a quiet, deadly weapon. A lease pendens is a public notice that your property is the subject of a lawsuit. It effectively puts a cloud on your title. With that on your record, you can't sell your house. You can't refinance it. You can't even get a home equity line of credit. You are trapped. It freezes your most valuable asset, holding it hostage while the lawsuit plays out. The goal is to isolate you and increase the pressure, to make you feel like the walls are closing in, so that you'll call them up and beg for a settlement. James felt a wave of nausea. This was so much bigger than a debt collector. This was the legal system itself being turned against him. His cease and desist letter felt laughably naive now. He hadn't scared them off. He had just forced them to show their true power. He knew with absolute certainty that he could not handle this alone. He needed a lawyer. He spent the next 2 days in a frantic haze, calling law offices. The experience was a soul-crushing education in itself. The first lawyer, a general practitioner, listened for 5 minutes and said, "Well, did you owe the money?" When James tried to explain the statute of limitations and the second mortgage, The lawyer cut him off. "Look, it sounds complicated. It'll be cheaper to just work out a payment plan with them." The second lawyer, a real estate specialist, was even more dismissive. He looked at the paperwork and said, "Their documents look to be in order. They have a copy of the note. You should probably look into a short sale or a deed in lieu of foreclosure to avoid having a foreclosure on your credit." They were advising him to surrender before the first shot was even fired. They saw a homeowner in default and a plaintiff with a mortgage, and they took the path of least resistance. They didn't understand the unique nature of a zombie mortgage. They didn't see the rot underneath the surface. James was losing hope. It felt like the entire system was rigged, that no one was willing to fight for him. He was about to give up when a friend of a friend recommended a small firm that specialized in one thing: foreclosure defense. He made the call, his voice cracking with stress. He spoke to a paralegal who didn't rush him. She listened to the whole story, from the original loan to the bankruptcy to the certified letter and the lawsuit. She asked pointed questions. When was your last payment? Who was the original lender? Did they attach a full chain of assignments to the complaint? James didn't know what that meant, but he felt the first glimmer of hope. These people spoke a different language. He got an appointment with the lead attorney the next day. Her name was Sarah Chun, and she had the calm, focused demeanor of a bomb disposal expert. James laid out all the papers on her conference table. She spent 20 minutes reading in silence, her pen occasionally underlining a phrase or scribbling a note in the margin. When she finally looked up, she didn't offer false reassurances. She said, "This is a classic zombie second mortgage case. The trust that's suing you likely bought your debt, along with thousands of others, for pennies on the dollar from the wreckage of the 2008 crash. Their entire business model is based on volume and intimidation. They count on the fact that 95% of people, and their lawyers, will do exactly what you've experienced. Roll over and pay up or give up the house." She slid the complaint across the table. "Their case looks strong on the surface, but these things are often a house of cards. They're showing you a copy of the note and mortgage, but the real question is, can they prove they actually own it? Can they produce an unbroken, legally valid chain of ownership, what we call the chain of assignment, that traces this debt from the original bankrupt lender, through every entity that bought and sold it, all the way to their trust? Every link in that chain had to be properly documented and recorded. If even one link is missing or forged or improperly executed, their entire case falls apart. They have no standing to sue you. They're a stranger to the debt." For the first time in weeks, James felt like he could breathe. She wasn't just a lawyer. She was a strategist. She saw the battlefield from a different perspective. "Our job," she continued, "is not to argue whether you once owed the money. Our job is to force them to prove, under the strict rules of evidence, that they are the ones you legally owe it to today. We are going to challenge their standing. We are going to demand they produce every single piece of paper documenting the life of this loan. We are going to put their entire house of cards on trial." The fight wasn't over. In fact, it had just begun. But now James wasn't fighting alone. He had found someone who knew how to slay a zombie. The lawyer's name was Anna Ramirez, and she wasn't just any lawyer. She was a foreclosure defense attorney who had built her entire career on one simple, powerful principle: the bank is not always right. When James laid out the whole chaotic story, the charge-off, the silence, the sudden reappearance of the debt collector, Anna didn't look surprised. She just nodded slowly, a small grim smile on her face. She'd seen this ghost before. "They're counting on you being terrified," she told him, her voice calm and sharp as steel. "They're counting on you not knowing the rules of the game. But we're about to change that. We're not just going to play their game. We're going to make them play ours. And our game has one very simple rule: show me the paper." This was the heart of their strategy. A legal concept so fundamental it's almost shocking how often it gets ignored. It's called produce the note. In the United States, for someone to foreclose on your home, they have to prove they have the legal right to do so. It's not enough to just say you owe them money. They have to prove they are the legitimate current owner of your debt. To do that, they need the original promissory note, that piece of paper you signed at closing promising to pay back the loan. And they need a perfect, unbroken chain of ownership called assignments, showing how that note traveled from your original lender, through any number of other banks or investors, to them. Think of it like the title to your car. You can't just walk up to someone, claim you own their car, and take the keys. You need the physical title with a clear record of ownership. A mortgage is no different. Anna explained that during the housing boom of the mid-2000s, these mortgage notes were bought and sold at a dizzying pace. They were bundled together into massive securities, chopped up, and traded like playing cards in a high-stakes Wall Street casino. In the rush to make money, the paperwork got sloppy. The chains of ownership were broken. Sometimes the original notes were lost entirely. The banks assumed no one would ever call them on it. They assumed the homeowner, panicked and ashamed, would just give up. The zombie's weakness, Anna said, leaning forward, is that it often has no memory of how it was created. It just knows it's hungry. Our job is to force it to look in the mirror, to account for its own existence. The first step was to go on the offensive. Anna filed a formal response to the foreclosure lawsuit, but it wasn't just a denial. It was a demand for proof. It was a multi-page document that essentially said, "You claim to own this debt? Prove it. Produce the original note. Show us every single assignment, every transfer, every piece of paper that documents this loan's journey from the day it was signed to this very moment." This legal maneuver is called discovery, and it's where the battle truly began. The debt collection agency's lawyers responded exactly as Anna predicted. First, they tried to stall. They filed motions for extensions, claiming they needed more time to gather the documents. Weeks turned into a month, then two. They were hoping James would run out of money or nerve. But James was paying Anna, and his nerve was now forged in cold anger. He wasn't backing down. When the stalling tactics failed, the agency moved to phase 2, the document dump. One afternoon, a delivery truck dropped off a dozen heavy boxes at Anna's office. It was thousands upon thousands of pages. Most of it was useless filler, generic corporate filings, irrelevant internal memos, duplicates of the same statements printed over and over. It was a classic intimidation tactic. They were trying to bury them, to make the task of finding the truth so expensive and time-consuming that they would simply give up. But they had underestimated Anna Ramirez. She lived for this. She and her small team, fueled by coffee and a righteous sense of fury, started digging. They weren't just looking for a needle in a haystack. They were analyzing the hay itself piece by piece. And slowly, painstakingly, the cracks began to appear. First, they found the assignment documents. These were the legal papers that supposedly transferred James's mortgage from one bank to another. But something was wrong. One signature looked suspiciously like another, even though they were for different people at different banks. The dates were impossible. A document notarized in Florida on a Tuesday was supposedly signed by a bank executive in California on that very same day. This was the infamous practice of robo-signing, a hallmark of the foreclosure crisis, where low-level employees forged signatures on thousands of documents a day without any verification, just to push the paperwork through. Then they looked closer at the entity that was actually suing James. It was DBA Holdings LLC, a name he'd never heard of. But the assignments they provided showed the loan being transferred from his original bank to another bank and then to a third. There was no mention of DBA Holdings LLC anywhere in the chain. There was a missing link, a giant, gaping hole in their story. The entity trying to take his house couldn't even prove they had the right to be in the courtroom. The biggest bombshell, however, was what they didn't find. After months of legal wrangling, after motions to compel and threats of sanctions from the judge, the debt collector's lawyers finally admitted it in a terse one-sentence letter. They could not locate the original promissory note. The wet ink, signed at the closing table, legally binding document that formed the entire basis of the debt, was gone. Lost somewhere in the great paper shredder of the financial crisis. All they had was a copy. In many jurisdictions, a copy isn't good enough. James felt a surge of something he hadn't felt in years: hope. The monster that had been haunting him, this terrifying, all-powerful entity, was starting to look clumsy, incompetent. It was a zombie, all right, but it was a zombie tripping over its own feet. Anna used this momentum to turn up the heat. She filed a motion for summary judgment. This is a legal power move. It essentially asks the judge to end the case immediately, arguing that based on the undisputed facts, the other side cannot possibly win. Her argument was devastatingly simple. 1. The plaintiff, DBA Holdings, has failed to demonstrate standing. They haven't proven they are the real party of interest because there's a fatal gap in the chain of ownership. 2. The chain of ownership they did provide is riddled with fraudulent and impossible-to-believe documentation, likely the product of robo-signing. And 3. The most powerful blow, they cannot produce the original note. They have no physical proof of the debt they claim to own. They are asking this court to take a family's home based on a shoddy photocopy and a broken chain of lies. The house of cards was not just on trial, it was wobbling. The debt collector's lawyers, so arrogant and dismissive just months before, were now backpedaling. They asked for another extension. They said they were working to cure the deficiencies in the paperwork. That's legalese for "we're trying to fake the documents we need, but we haven't finished yet." The judge, a no-nonsense woman who had seen hundreds of these cases, set a final hearing date. No more extensions. No more games. She ordered both parties to appear in her courtroom in 30 days. Everything would be decided then. The debt collectors had one last chance to either find the proof they needed to legally foreclose, or their case would be dismissed. For James and his family, it was 30 days of agonizing tension. They had the truth on their side. They had a brilliant lawyer. They had exposed the zombie for what it was, a hollow shell, animated only by greed and paperwork. But they were still in a courtroom, and in a courtroom anything can happen. The bank wasn't just going to roll over and die. A cornered animal is the most dangerous, and this zombie, deprived of its meal, was about to try one last desperate attack. The bank's lead attorney, a man who looked like he'd been carved from polished granite, stood up slowly. He adjusted his tie, not with a nervous twitch, but with the deliberate calm of a predator repositioning for a final strike. He didn't address the homeowner or their lawyer. He spoke directly to the judge, his voice echoing with a confidence that seemed entirely out of place. He argued that the statute of limitations, this 6-year clock that was their salvation, had been paused. Told was the legal term he used. And then he told the court why. Years ago, long after the foreclosure case was dismissed and the silence began, the homeowner had sent the bank a letter. It wasn't a legal document. It was a human document. A hardship letter. It was a desperate 2-page plea written late one night at the kitchen table, explaining a temporary job loss, a medical bill, asking, begging, really, if there was any kind of modification program they might qualify for. They were trying to be responsible. They were reaching out, trying to do the right thing, trying to find a solution. They never even got a reply. To them it was a message sent into the void, another dead end. But the bank hadn't seen it that way. The bank had saved it. And now, in the middle of this courtroom, they were pulling it out like a trump card. The bank's lawyer claimed this letter, this plea for help, was a legally binding acknowledgement of the debt. And under state law, he argued, a written acknowledgement of a debt could restart the statute of limitations from the date the letter was sent. All that time the clock was ticking down? It didn't count. The letter, he thundered, was a reset button. That 6-year window hadn't closed. In fact, it had just started all over again. The room went cold. The homeowner felt the air leave their lungs. The very act of trying to be proactive, of reaching out for a lifeline, was now being twisted into a noose. This is one of the most insidious traps in the entire world of debt. It's a legal landmine buried in the fine print of state law, and millions of Americans have no idea it even exists. Imagine you're running a marathon. You see the finish line. You've been running for years, you're exhausted, but you're almost there. Then, an official steps out and tells you that because you stopped for a cup of water 5 miles back, you have to go all the way back to the starting line and run the entire race again. That's what the bank was trying to do. They were using the homeowner's own moment of vulnerability, their own good faith effort to communicate, as a weapon to pull them right back to square one. The homeowner's lawyer was on his feet instantly, his voice a sharp crack in the stunned silence. He argued passionately that a hardship letter is not a promise to pay. It's a request for information. It's a statement of a condition, not an unconditional acceptance of a debt. He painted a picture for the judge, a family in distress, not a debtor calculating legal strategy. To interpret this desperate plea as a formal legal reaffirmation of debt was, he said, a perversion of justice. It was punishing someone for asking for help. But the bank's lawyer was ready. He had case law. He cited obscure precedents from decades ago where courts had ruled that much less formal communications had, in fact, reset the clock. The battle was no longer about the zombie nature of the mortgage. It had shifted to a new microscopic focus, the exact wording of a single forgotten letter. The lawyers began dissecting it sentence by sentence right there in open court. Did the phrase "my mortgage with you" constitute an acknowledgement? Did "I want to find a way to pay" count as a new promise? Every word was twisted and turned, its meaning debated, its intent questioned. The homeowner had to sit there and listen as the most vulnerable moment of their life was put on a slide under a legal microscope, analyzed by people who saw it not as a cry for help, but as a potential fatal mistake. The judge listened intently, his face unreadable. This was a gray area. This was a moment where the letter of the law and the spirit of the law were in direct conflict, and the entire case, the house, the family's future, now balanced on the tip of this legal needle. The homeowner's lawyer, seeing he might be losing the argument on the interpretation of the letter alone, decided to pivot. He went on the attack. He turned to the bank's representative on the stand, a mid-level manager who had been flown in for the hearing, and he asked a very simple question. Who exactly owned this loan on the day my client sent this letter? The manager blinked. He said the name of the bank. The lawyer pressed him. Can you prove that? Can you show me the unbroken chain of title, the assignments, the allonge, proving that on that specific date, you had the legal standing to even receive such an acknowledgement? And there it was, the Achilles heel of the zombie mortgage industry, the paperwork. In the great mortgage rush before the 2008 crisis, loans were bought and sold so fast, bundled and securitized with such reckless speed, that the actual legal documentation, the proof of ownership, often became a tangled, incomprehensible mess. Or worse, it was lost entirely. The bank's lawyer objected. Relevance, Your Honor? The homeowner's lawyer shot back. It's the most relevant thing in this room, Your Honor. They are claiming a letter sent to them had a specific legal effect. But if they didn't legally own the debt on that day, then the letter is meaningless. It's like sending a rent check to your old landlord after the building has been sold. It proves nothing. The judge leaned forward, intrigued. He overruled the objection. Show him the proof, the judge ordered the bank manager. The manager began shuffling through a thick binder. He looked flustered. He pulled out a document. The homeowner's lawyer examined it. This assignment is dated 6 months after my client sent the letter, he said, showing it to the judge. The manager fumbled for another. This one is undated. Another. This one is a transfer from a company that had already been dissolved. For the next hour, the courtroom watched as the bank's supposedly ironclad case began to rust and crumble under examination. The pristine chain of ownership they claimed to have was, in fact, a string of broken, contradictory, and missing links. The zombie, it turned out, wasn't just old, it was hollow. It had no clear history, no verifiable identity. They couldn't even prove who it was on the day it mattered most. Finally, after a brutal cross-examination, the bank's lawyer had nothing left. The homeowner's lawyer rested his case. He had exposed the bank's last desperate attack for what it was, a bluff, an attempt to win on a technicality that they themselves couldn't back up with evidence. The judge took off his glasses and rubbed his eyes. He looked at the family, who had been on this emotional roller coaster for what felt like an eternity. He looked at the bank's lawyers, their faces grim, their binder of documents now looking less like an arsenal and more like a pile of scrap paper. The entire courtroom held its breath. The fate of the home, the resolution of this decade-long nightmare, came down to this single moment, to this one man's interpretation of a forgotten letter and a phantom chain of title. He put his glasses back on, cleared his throat, and looked directly at the homeowner. He said, "In the matter before this court, we are faced not with a simple question of an unpaid debt, but with the ghost of a debt, a phantom conjured from the chaos of a financial crisis a decade ago." The room was silent. You could hear the hum of the fluorescent lights. The plaintiff, the judge continued, gesturing with his pen toward the debt collector's lawyer, has presented a series of documents purporting to show a transfer of this debt from the original lender through a series of entities, culminating with themselves. They claim this chain is unbroken and legally binding. He paused, taking a slow sip of water. However, a chain is only as strong as its weakest link. And in this case, the chain is not merely weak. It is, for all legal intents and purposes, non-existent. A quiet gasp rippled through the homeowner's side of the courtroom. The judge continued, his voice firm and clear. The plaintiff has failed to produce a complete and verifiable chain of assignment. They have provided bills of sale for vast portfolios of debt, containing thousands of accounts, but have failed to prove that this specific mortgage for this specific property was legally and properly included in each and every one of those transfers. They are asking the court to assume it was. The law does not operate on assumption. He then picked up the faded letter, the one the homeowner had found in that dusty box. Conversely, the defendant has produced a document from the original lender, the only entity with unquestionable standing in this matter, stating their intent to release the lien and discharge the debt. While not a formal reconveyance, it demonstrates the original creditor's disposition at the time. It shows the debt was considered settled, written off, abandoned. He looked over his glasses again. first at the plaintiff's lawyer, then at the homeowner. The plaintiff in this case is a debt scavenger. They purchased a portfolio of questionable assets for pennies on the dollar, hoping to intimidate a few homeowners into paying on debts that the original lenders had long since written off as uncollectible. Their business model relies on the assumption that the average person will be too frightened or too exhausted to fight. It relies on forgotten paperwork and the passage of time. But here in this court, the burden of proof is absolute, and they have failed to meet it. He put the letter down. Therefore, it is the judgment of this court that the plaintiff has no legal standing to foreclose on this property. The lien is invalid. The debt is unenforceable. This case is dismissed with prejudice. With prejudice. Those two words were the hammer blow. It meant the debt collector could never ever bring this case back to court again. It was over. For a moment, the homeowner just sat there frozen. The words didn't seem real. A decade of fear, of sleepless nights, of a shadow hanging over every family dinner, every holiday, every quiet moment gone. Then a sob escaped, a sound of profound, earth-shattering relief. The weight of 10 years evaporated in an instant. The ghost was finally exorcised. But this victory wasn't just about one family. It was a lesson for every single person who owns, or ever will own, a home in America. And the lessons are hidden in the judge's words. First, and most importantly, the burden of proof. When a strange company comes out of the woodwork claiming you owe an old debt, it is not your job to prove you don't owe it. It is their job, their absolute legal obligation, to prove you do. They must be able to produce a clear, unbroken paper trail from the original creditor all the way to them. This is called the chain of assignment. If there is a single missing link, a single improper signature, a single document they can't produce, their case falls apart. Second, the statute of limitations. This is a legal concept every American needs to understand. In every state, there is a time limit for how long a creditor can sue you to collect a debt. For mortgages, it's often complex, but for many other debts, it can be anywhere from 3 to 10 years. Zombie debt collectors buy debt that is often far past this statute of limitations. They know they can't win in court, so they rely on harassment and intimidation, hoping you don't know your rights. They hope you'll make a good faith payment of a few dollars. But here is the trap. In many states, making even a $1 payment on an old, time-barred debt can reset the clock on the statute of limitations, making the entire debt legally collectible again. It breathes life back into the zombie. So what do you do if this happens to you? If you get that terrifying letter in the mail demanding payment on a mortgage you thought was long gone, the first step is the hardest but the most important. Do not panic. And do not, under any circumstances, engage with them on the phone or send them any money. Your first move is to act, not react. You must send them a debt validation letter. You can find templates for free online. Send it via certified mail with a return receipt requested. This is your legal right under the Fair Debt Collection Practices Act, or FDCPA. This letter officially disputes the debt and forces the collector to cease all collection activities until they provide you with proof of the original debt and proof that they legally own it now. Many times, the collection agency will simply disappear after receiving this letter. They don't have the proof and they know it. They're just playing a numbers game and you've called their bluff. If they do send you documents, that's when you move to step 2, scrutinize everything. Look for that unbroken chain of assignment. See if the debt is past your state statute of limitations. And step 3, get professional help. Contact a nonprofit housing counselor or a consumer protection attorney. Many will offer a free consultation. This is not a fight you should have to fight alone. The homeowner in our story won because the system, when properly challenged, worked. But it begs the question, why does this happen at all? The answer lies in the fallout of the 2008 financial crisis. When millions of loans went bad, banks were sitting on mountains of toxic assets. To get them off their books, they bundled them into massive portfolios and sold them for pennies on the dollar to third-party debt buyers. These sales were often a mess. The data was incomplete, inaccurate, or missing altogether. Records were lost. Liens were never properly released. It created a feeding ground for bottom-feeder collection agencies who bought these flawed portfolios, knowing that inside a mountain of worthless data, there might be a few nuggets of gold, a few homeowners they could scare into paying. The homeowner was free. The court had declared their home their own, once and for all. But what happened to the company that put them through a decade of hell? The company that built a business model on resurrecting dead debt? And more importantly, what are the new, more sophisticated traps that have emerged from the ashes of the old ones? Traps that could put your property at risk today, even if you think you've done everything right. The answer involves a quiet, almost invisible change in how property records are being managed across the country. A digital shift that is creating a new breed of zombie that is harder to spot and even harder to kill. And that is the final, most crucial piece of this puzzle. It's a system called MERS, the Mortgage Electronic Registration Systems. And if you've gotten a mortgage in the last 25 years, there's a very good chance you've seen that name on your paperwork. On the surface, it sounded like a great idea. Back in the 90s, as Wall Street started packaging and selling mortgages like trading cards, the old system of physically going to a county courthouse to record every single time a loan was sold became slow and expensive. So, a group of the biggest banks created a shortcut. They created MERS, a private company, to act as a nominee for the lender. Think of it like this. Instead of recording the name of Bank of America, then Chase, then Wells Fargo in the public record every time your loan gets sold, they just record one name, MERS. MERS then holds the mortgage on behalf of whoever actually owns the loan. And that real ownership information is tracked privately on MERS's own electronic database. It streamlined the process, making it faster and cheaper for Wall Street to trade trillions of dollars in mortgage debt. But in doing so, it created a smokescreen, a digital fog that has settled over the public land records of the entire country. Because now, when you go to your county recorder's office to see who owns the mortgage on your home, you don't see a clear chain of title. You see a single entry, MERS. The actual owner, the entity with the legal right to foreclose, is hidden behind a corporate veil, their identity known only to a private database. And this is where the new, more dangerous zombie is born. During the 2008 financial crisis, hundreds of lenders went bankrupt. The loans they originated were sold off in chaotic, fire sale bundles. Paperwork was lost. Entire mortgage portfolios were transferred with little more than a spreadsheet. And in this chaos, the single most important document in the entire process often vanished: the original promissory note. The wet ink that you signed at closing. The physical piece of paper that is the actual proof of your debt. Under centuries of property law, to foreclose on a home, the entity suing you must be able to produce that original note. It's the legal equivalent of showing the deed to a car. But what happens when the note is gone? Lost in a failed bank's basement, accidentally shredded during a transfer, or simply vanished into the digital ether? The debt still exists on a computer screen. MERS might have a record of who it thinks owns the loan, but the legal standing to actually collect on that debt is broken. The mortgage is now a digital ghost. It haunts the title of your property, alive in a database but dead in a court of law. Let me tell you about the Richardson family in Florida. In 2006, they bought their dream home. They signed the papers, got their keys, and their mortgage was, of course, registered with MERS. Then the crash happened. Their original lender went belly up. They got a notice that their loan was sold to a new servicer. Then another. And another. For years, they just kept paying whoever sent them the bill. Then, in 2014, Mr. Richardson lost his job. They fell behind. A foreclosure notice arrived from a company they'd never heard of, Apex Asset Resolution. Their lawyer did something very simple. He filed a motion in court with a 3-word demand: produce the note. Apex Asset Resolution sent a copy. The lawyer objected. They sent a certified copy. The lawyer objected again. They needed the original, the one with the real ink signature. Weeks turned into months. Apex couldn't find it. They claimed the previous servicer was supposed to have it. That servicer claimed it was with the servicer before them. The paper trail was a tangled mess, a decade-long game of hot potato where the potato had been vaporized. After a year of legal battles, the judge had no choice. Foreclosure case dismissed. The Richardsons, it seemed, were in the clear. But they weren't. The case was dismissed without prejudice, meaning the lender could try again if they ever found the note. The zombie wasn't killed. It was just sent back to its grave waiting. The Richardsons couldn't sell their home because no title insurance company would touch it. They couldn't refinance. They were trapped, living in a house they didn't technically own free and clear, with a multi-$100,000 digital ghost hovering over them. This is the new reality. It's not about a bank forgetting to file a piece of paper. It's about a systemic breakdown in the chain of ownership, masked by a private database, that can leave millions of homeowners in a state of permanent legal limbo. So how do you protect yourself? How do you fight a ghost? This is the most important part. This is where you turn this knowledge into a shield. First, you need to know if you're in the system. Go to the MERS website. They have a free tool called MERS Servicer ID. You can type in your property address and it will tell you if your loan is registered with them and who your current servicer is supposed to be. Check your original mortgage documents. The name MERS will be on there, usually identified as a nominee for the lender. Knowledge is the first step. Second, become an obsessive archivist. In an age of digital uncertainty, physical proof is your sword and shield. Keep every single document related to your home and mortgage in a fireproof box. I mean everything. The original closing packet, every monthly statement you've ever received, every letter announcing a change in your loan servicer, and most critically, when you finally pay off your loan, the original satisfaction of mortgage or deed of reconveyance, and the original promissory note marked paid in full. Do not accept a copy. Demand the original. That piece of paper is your proof of freedom. It's the stake through the zombie's heart. Third, actively monitor your property's title. You monitor your credit score for fraud, right? You need to do the same for the title to your home, your single biggest asset. Many county recorder offices across the U.S. now offer free property fraud alert services. Sign up for them immediately. They will send you an email or text alert anytime a new document, a lien, a transfer, a notice of default, is filed against your property. This is your early warning system. It can stop a zombie mortgage claim before it even gets started. Fourth, understand the produce the note defense. If you ever face a foreclosure from a company you don't recognize, the first thing your attorney will likely do is challenge their legal standing to sue. They will demand that the foreclosing party produce the original, wet ink promissory note, along with a full, unbroken chain of all the assignments proving they are the true owner. The inability to do this is the Achilles heel of the digital zombie. It's the legal silver bullet that has stopped thousands of foreclosures in their tracks. And finally, for those already trapped, or for those who have paid off a loan but the lien was never released, there is a definitive weapon: a quiet title action. This is a special type of lawsuit where you sue any and all parties who might have a claim to your property and force them to come to court and prove their claim. The judge then issues a final, binding decree that declares you the sole rightful owner, extinguishing all other potential claims. It clears the cloud from your title permanently. It's not cheap and it requires a good real estate attorney, but it is the ultimate way to kill a zombie mortgage for good and reclaim your peace of mind. We started this journey looking at decaying houses in forgotten neighborhoods, a physical manifestation of a legal problem. But we've discovered the threat has evolved. It's gone from a neighborhood blight to an invisible digital blight that can affect anyone, in any neighborhood. It's a ghost in the machine, born from a drive for efficiency on Wall Street, that ignored the centuries of property law designed to protect homeowners. This isn't about scaring you. It's about arming you. Your home is more than an asset. It's the center of your life. Protecting it is not just about paying the mortgage on time. In the 21st century, it's about understanding the complex, often invisible systems that govern its ownership. It's about being vigilant. It's about keeping meticulous records. It's about knowing your rights. The zombie mortgage is the perfect metaphor for our times. A problem created by a complex system that then forgets its own rules, leaving ordinary people to deal with the consequences. But now you know the rules. You know where the zombies come from, how they hunt, and most importantly, how to defeat them. They aren't coming for your brains. They're coming for your equity, and the only thing standing in their way is your knowledge.